Now we are on the record in the matter of the state of Michigan versus Lavour, 2546. And Detective, your name for the record, please.
Detective Devin Geiger, Wyandotte Police Department.
I think you may proceed on the warrant.
On January 6, 2025, approximately 1:30 in the morning, officers Tyler Grote and Kyle Cox were in a fully marked patrol vehicle and fully marked uniforms of the Wyandotte Police Department and observed a Chevy Impala operating on 4th Street with an improper license plate light, or defective light, I should say. A traffic stop was effected near Fort Antoine, and contact was made with the operator and sole occupant, Sean Lavour. Officers were speaking with Ms. Lavour. They, during conversation, asked if she had any illegal narcotics or anything in the vehicle. She provided a body gesture indication that there may have been something in the vehicle towards her purse. The officers asked if the consent search of anything on her, and she admitted that she had prescription medication. They asked if they could see the prescription bottle. She handed it over. The officers then noted that there were several types of medications in the bottle, several different types of pills. They asked for consent for her to step outside of the vehicle. She admitted that she had bought some Adderall from somebody prior to the stop. Officers asked for consent to search the vehicle. It was at that time they located approximately 12 strips of Suboxone in her purse and in open packages in the vehicle. We did a MAPS report on Ms. Lavour. She does not have any prescription history for this medication or for this controlled substance. She has one prior habitual offender, one felony conviction back on August 2016 at Third Circuit for counterfeiting possession of money. And that's it, Your Honor.
All right, thank you. Please issue the complaining witness. I find that the defendant, or that the offense charge was committed, there's probable cause to believe the defendant committed that offense.
Sean Marie Lavasseur.
All right, and
Your Honor, as to the charge, I advised her of her constitutional rights. She understands those constitutional rights. She would stand mute to the charges, waive a full reading of that charge, and ask that a plea of not guilty be entered. Your Honor, I wouldn't want to address
the court's going to waive the full reading. You have the right to have an attorney. If you cannot afford an attorney, the court will appoint one to represent you. And in fact, you've had an opportunity to speak to an attorney today, correct?
Yes.
All right, the court has also signed a petition for court-appointed attorney for felony matters. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury. You also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights?
Yes, ma'am.
The court's going to enter a plea of not guilty on your behalf. Schedule this matter for a probable cause conference on January 16th at 10:15 a.m. And counsel, what is it that you wanted to address?
Your Honor, there is an habitual offense notice.
Yes.
However, I reviewed the criminal records, and she was acquitted of those charges back in, I believe it was 2016. She was charged with counterfeiting. It was a coin issue. A review of the file indicates to me that she was acquitted, and that's what she's also referred to.
There's one count, she was found guilty. She was found guilty on count 1, found not guilty on count 2.
Okay.
That's what this shows from
Okay, I must have missed
August 2nd of 2016. Well, it's on 2 pages, so, yes, does that ring a bell for you, Ms. Lavour?
Yeah, there was 2 counts. One not guilty, one was guilty.
Correct.
Yes. Misread, I just saw the last one. Okay,
All right.
thank you.
And so then ask to bond counsel.
Your Honor, Ms. Lavour will be 40, or she's 44 years old. She has a number of misdemeanors. Her last contact, I believe, was 2017 out of Wyandotte, Woodhaven, and Wyandotte, Woodhaven, and Southgate. Also, Your Honor, out of Washington County, I apologize. And as well as the prior one. She's never failed to appear. She's not on probation or parole at this point in time. As I indicated, she's 4 years old. She's single. She lives with her mother. She has been self-employed for the last 20 years in the flea market business, as opposed to sitting down and working at a job, but she's self-employed in that area. Her last contact was in 2016 or 17. We had asked for a reasonable bond under these circumstances. It should be noted that in her prior contacts, or at least prior record, she has no drug-related offenses. We're asking for a personal bond in this particular matter under the circumstances.
Okay, ma'am, you're not currently on probation or parole anywhere?
Are you on probation or parole anywhere?
No, I'm not. Nope, I haven't anything since 2000. I got out of jail or prison in 17. Sorry.
Okay. And so, the flea market business in Michigan isn't very, plentiful right now in the winter season, is it?
I'm gonna get 9 to 5 job. I didn't go into details with him, but it's time to get out of the market and go back to what I know. I held a job for over 20 years.
And where did you work for 20 years?
The Best Western in the Holiday Inn 75 and West Road. It was owned by the same.
Okay.
Same.
And did you lose that job when you went to prison, or?
No, I decided to separate from there, and I raised 3 boys for the last 10 plus years. They're not my biological boys, but their dad separated from their mom, and that's who I am since then.
So you worked there for 20 years and you left there to raise the boys for 10 years. That puts you at 30. That's 30 years and you're 44. So at 14, you started working?
Yeah, 14. All through high school, whenever I wasn't in school, I was working.
Okay. All right, if you were to test today, what's in your system?
That's it.
It didn't come through. What was that?
It's Adderall. If it's systems, I have nothing else in my system.
Okay. All right, and detective, would you like to address bond?
It looks like she lives locally. She was cooperative with officers. I just suggest no drugs other than prescribed, and just a bond assured presence, $200, $250 cash.
Okay. So, ma'am, who lives at home with
My mom.
you? Okay. So are you not with the individual that had the three boys?
I don't believe they were not her biological children.
I know, that's why I asked if she was still with the parent of the 3
Yes,
boys.
I still am. I still am. I stay with my mom more.
Okay. And so you have somebody that can post about $250 bond for you, ma'am?
Yes,
All right.
yes.
Given the habitual offender second offense notice, the court wants to ensure your presence. The court's going to order a $2,500 10% bond. You're not to possess or consume any alcohol or drugs unless prescribed. And you need to work on obtaining employment, ma'am. All right, and then we'll see you back on the 16th.
I'm sorry, the 16th?
January 16th.
16th.
Thank you.
That would be the PCC. Thank you, Your
All
Honor.
right, thank you. We're on the record in the matter of Dina Wise, 2323658. For B, I mean. This one's B. All right, and counsel?
Good afternoon, Your Honor. Your Honor, John, excuse me. Your Honor, John Goldpool, P 307-8 on behalf of Ms. Wise. Ms. Wise, would you please put your name on the record?
Dina Marie Wise.
Okay, and so today's the date for the probation violation hearing. In this matter, so first, your client's on probation for possession of controlled substance. This is alleging technical violations 1 through 5. Alleged your client failed to appear for probation visit December 3rd, failed to appear chemical awareness program on December 2nd, failed to appear for drug testing December 3rd, December 16th, and December 26th. And counsel?
That is correct, Your Honor. I discussed this matter with Ms. Wise. I've advised her of her right to a hearing in this particular matter, and I've also advised her of her constitutional rights. Discussing this with Ms. Wise, it's my understanding that she will plead guilty to the violations, and through this plea, beg for the court's mercy because you'll hear what's going on in her life.
Ms. Wise, please raise your right hand. You solemnly swear affirm the testimony about to give in this matter be the truth, the whole truth, and nothing but the truth.
I do.
All right. And you heard the allegations that were placed on the record, correct?
Pardon?
You heard the allegations that were placed on the record, correct?
Yes.
I'm under the weather. And as to those allegations, how do you plead?
I plead guilty.
And you've gone over your advice of rights for probation violation purposes, correct?
I have, yes.
And you understand all of these rights.
I do.
And you also understand by entering into a plea, you'll be waiving some of those rights.
Yes.
You also understand the possible penalty as a result of your plea to this probation violation, and that the recommendation is for your under advisement status to be revoked, your probation to be revoked, case closed without improvement, $50 probation violation fee, and 20 days jail. Do you understand that that's the recommendation?
Yes.
And knowing all that, do you want to continue with your plea?
I do.
Has anybody promised you anything, threatened you, or forced you in any way for you to enter into a plea today, ma'am?
No.
All right, counsel, if you can please argue your client.
Thank you. Ms. Wise, you're placed on probation to this court, is that correct?
Yes.
And as part of the terms and conditions of your probation, you were to attend probation meetings, chemical awareness program, and submit to drug testing, is that correct?
Yes.
And on December 3rd, did you fail to appear for probation?
I did.
And on December 2nd, did you fail to attend a chemical awareness program?
I did.
And on December 3rd, did you also fail to submit to a drug test?
I did.
And did you fail to submit to drug testing on the 16th and the 26th of December as well?
Yes.
Defense satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the probation violation, indicate technical violations 1 through 5 will enter. And counsel, ask the recommendation.
Your Honor, the whole last year, speaking to Ms. Wise, has been somewhat of a disaster. She's trying to get her life turned around. She's trying to get everything straightened out within her life. Her family life is basically going to extreme language hell. In the last month or two, her husband, who is her sole support, pays all the bills, takes care of all the business. They have now finally separated. She has no money to file for divorce. He comes and goes, doesn't take care of anything except himself, it appears. She lost 2 jobs over the last few months. In fact, she lost her job approximately a month ago. She is trying to get employed, but more importantly, she's trying to get her head turned on straight. She knows she needs these programs. The recommendation is to revoke and also to revoke the under advisement status. If that happens, then of course there'll be not only the other consequences from this court, but also this would now affect her driver's license because of the drug-related matter. She is trying to get another work. She has an appointment scheduled to enter into some sort of self-employment arrangement she's meeting with, I guess, her niece. Pardon?
My cousin.
Your cousin, who is a paralegal to help draw up the paperwork. This is, and I'm just reviewing what I reviewed. She's been on probation for approximately, I'm sorry, Your Honor, when was she placed on probation?
March
March. Yeah, February.
March. And
18th.
and this is the first time she's violated probation, or, there's been violations, so we are, here she's been struggling through all these 9 months. I know there's things that have to be done, but I don't know if revoking her advisement status, putting her in jail, and revoking probation is the appropriate way to go. If the court feels because of this that there is a need for some sort of jail review, or at least jail, ending her probation is not gonna solve the question. It's just gonna put her in jail and she'll owe you money. I'm asking rather that probation be continued, that the under advisement status be continued, and she'd be able to turn herself around, get a job, or at least get the support she's owed from her husband so she can make these payments, and, suspend any kind of jail sentence at this time.
Okay, let me ask these questions to you, ma'am.
Yes.
Have you been attending the fan meetings?
I have not. I haven't. And I apologize.
Have you,
I have never.
Excuse me, it's yes or no? It was yes or no. Have
No.
you had any mental health counseling?
No, I have not. I've seeked out someone, and I'm pretty sure it's just money. I don't have any money.
No,
So-
hold on, ma'am.
Yes,
Do you have any health insurance?
I do have health insurance. So with the counseling, which I know I need immensely. She is seeing if my insurance, which I have Aetna through the state, to see if she will accept that. Because I really like this one.
Yeah. When did you start that process?
This around Christmas time.
Okay, well, you were sentenced in March.
I know.
Counsel, your client hasn't done anything.
I understand, Your Honor.
She has done zero. And in fact, the court even at sentencing indicated mandatory revocation of under advisement status for any violation. So, when's the last time you saw your probation officer, ma'am?
I seen her last year. Well, December. No, excuse me. Oh, November. In November, and I was supposed to see her in December. It's been extremely hard the past 2 months, but my gas got shut off. It's nobody's problem. I take accountability. I just know I don't deserve anything. I don't deserve it. However, I believe I'm worth it. I've never given it a chance.
So your client, other than meeting with probation once a month, has done nothing. And quite honestly, I think the violation should have come forth a little bit sooner regarding not attending fan meetings and not having mental health counseling.
May I have another chance? I know I can do it. I don't hurt anybody. I don't bother anybody. And I just have always been hard-headed as far as what people think I need. But sometimes people know what's best for me, And I'm just ready to do that. I'm ready 100%.
Okay, good. I'm going to order 20 days jail. I'll suspend 15. She's going to serve 5. And we'll continue probation. Under advisement status is revoked per the court's previous order of probation. And
Your Honor, would the court reconsider that aspect of it?
no.
I don't have anybody to take care of I don't have anything. Please.
Ma'am,
Please. Yes.
what do you need? What do you need somebody to take care of?
My home, everything, just everything.
Well,
Could you please reconsider, please? Like I said, I don't deserve it. I know I don't.
Excuse me, let me just clarify, ma'am. You
Okay.
haven't done any of your mental health counseling.
But I will.
You
I
stop,
will.
stop. It's my turn to speak.
Okay.
When I crafted your sentence, I took into account all of your needs. I crafted the sentence according to your needs.
Okay.
You blew a lot of those needs off. You didn't go to your fan meetings, you didn't attend mental health counseling, and for the month of December, you pretty much did nothing that you were supposed to do.
Yeah, I'm a jerk.
Please stop. You were given the benefit of the under advisement status, and I ordered at that time, if there are any violations, you are going to lose that under advisement status. So, you now have 5 violations. I absolutely am not going to continue the under advisement status. You had much notice, and quite frankly, you should feel fortunate in the sense that you weren't before the court previously for probation violations because you were not attending FAN and you were not attending mental health counseling. And you have insurance.
Your
So,
Honor.
I'm going to order 20 days jail. I'm suspending 15. You can report Friday, January 10th. That gives you a couple days to arrange for somebody to take care of your house.
Okay.
I'm going to continue your probation. I'm also going to extend it 6 months from your original end date. You are to enroll in mental health counseling
Okay.
within 24 hours of today, because you know when you're going to be out of jail.
Hey. Pardon, what was that? What did you just say?
You are to enroll in mental health counseling within 24 hours. So
Okay.
for today, you need to email into your probation officer with the date of your screening with your mental health provider.
Okay.
And I'm going to go out on a limb here and ask if you've performed any of your community service hours.
I have not.
I didn't think so.
I know. I apologize. Sincerely, I do. I know you've heard it all.
You are to attend the FAN meetings beginning Thursday, January 16th. No excuses, ma'am. 0.
Okay.
0. One more violation, ma'am. And this is all out the window. You're serving the balance of your 15 days and any other days that this court adds on.
Okay.
If you
May I?
If you were to test right now, what's in your system? If you were to test right now, what is in your system?
There's no alcohol and maybe some Adderall. I'm just completely lost. That's all. That's honest.
Are you prescribed Adderall?
I am not.
Okay.
I am not.
So here's what I'm going to do, counsel. I'm going to reverse it. I'm going to have your client serve the 15 days, suspend 5, and she's to be tethered to treatment through the Wayne County Jail. That will be a jump start on her treatment that she needs so desperately, that she's also indicating that she really wants.
Same report taken.
So, Your Honor. Your Honor,
Yes.
may I say that I've never had trouble with drugs. Once in a while, I'll, get down on myself and do something. My thing is, and please hear me, my thing is trauma. I haven't dealt with it. That's my thing. It's not drugs. It's trauma. And then trauma for me leads to me being irresponsible, like so as today. And from the time I've seen you with this case, it's the trauma. And I deflect all of the time. It's not drugs. It's me, a personal thing in my head, things that have happened to me in my past, and they're extreme. And I just feel like everybody goes at the wrong thing with me when I'm telling you now. And just sort of reaching out for help when it comes to just, I need counseling. I desperately need counseling. And I know if I go to like these meetings like you're talking about and asking me to go to and ordering me to go to, I know I have to give forth and put effort. I know I do, and I want to. I'm 46 years old, and I've never admitted that I need counseling and I need help because I'm okay. I can put things down. I can leave things alone. I just don't deal with my trauma, and I need help with that. I don't want, it's always been ignored my whole entire life since I was a little girl, since I was 5 years old. Just ignore it and kind of go for what the big thing that's in everybody's face. But I'm here telling you as a woman, and I know my position in life, but I just need help with my trauma. I have a lot of trauma.
Okay, and ma'am, I can appreciate that.
Oh, it's hard to hear you. It's hard to hear you.
I said I can appreciate that. However, you were afforded an
Your Honor, I
opportunity.
have to put my phone on the charger. I apologize. I'm taking you with me.
You were
And
afforded.
it's hard to hear you because.
So, ma'am,
Okay.
you were afforded an
Okay.
opportunity.
Hello?
You were afforded.
There you
You were afforded an opportunity, ma'am. Okay, I don't really want to look into your ear canal, please.
I know I was.
And, ma'am,
Like I said,
I let you speak.
I'm not trying to.
Please let me speak. But before I do that, have you ever lived in Florida?
Okay.
Have you? Okay.
I've been to Florida, yes.
Do you have another last name that you're known by?
My maiden name?
Yes. Which was?
Yes. Yes, ma'am. Absolutely.
So you're telling this court that you don't have a drug problem, that drugs isn't your thing. However, there are some drug convictions from Florida. And you're here for possession of controlled substance charge. And
it was drug paraphernalia. It wasn't an actual drug.
ma'am, you're deflecting, right?
Yes.
So you say that that your coping is deflecting, but you continue to deflect. So I'm going to help you, and you're going to report to Wayne County Jail on Friday. You're going to serve 15 days. You're to be tethered to treatment. The court is going to suspend 5. Your under advisement is revoked because, quite frankly, I'm not sure how you even got the under advisement since you have prior drug convictions from Florida. But in any event, that was recommended, so perhaps that wasn't caught the first time, I don't know. However, all the other things that I stated are going to remain, except for the fan meeting. You obviously won't be out to attend that. You need to attend the fan meeting beginning in February.
Okay,
If you do not report to jail on Friday, the warrant will be issued for your arrest. So you're going to
I understand.
You're going to email into Ms. Shine, and she will give you the instructions as how to report. Okay?
Okay.
So I expect that you'll be at the February 20th fan meeting.
February 20. Okay.
Yes.
Your Honor, I would like to apologize to you for if it seems I'm being disrespectful and ugly. 'Cause I'm not.
Nope. No apology necessary. You're fine.
Yeah.
All right. Email into Ms. Shine by 1:30.
Thank you. Good luck.
Yes, today.
Okay, I'll email her. Thank you.
All right. So we're on the record in the matter of the state of Michigan versus Bradley Thomas Peterson, 33rd District Court, case number 25W700388. And Detective, if you can please state and spell your names for the record, please.
Yeah, Detective Sergeant Robert Vespremi with the Woodhaven Police Department. I am speaking and swearing on behalf of Detective Kyle Davis with the Woodhaven Police Department.
Okay, can you please spell your last name, Detective Sergeant?
Yeah, V as in Victor, E S, P as in Paul, R E M I.
I think you may proceed on the warrant.
Yeah, on January 6th, 2025, at approximately 8:20 a.m., hours officers responded to 24821 Hall Road. This is a Woodhaven Brownstown School District Board office. There, Bradley Peterson was observed protesting and found to be trespassing. Mr. Peterson was arrested for trespassing and transported to the Woodhaven Police Department. While at the Woodhaven Police Station, Mr. Peterson refused to cooperate, entering the police station inside of the booking room and in his cell. While in the booking room, Mr. Peterson was physically resisting and trying to kick Officer Cash with the Woodhaven Police Department, who was standing behind Mr. Peterson, trying to maintain Mr. Peterson's compliance. During Mr. Peterson's resisting, Sergeant Baker advised Mr. Peterson grabbed his right hand and squeezed it very tight, resulting in Sergeant Baker to sustain a pinky finger injury. Sergeant Baker later went to the local urgent care for his injury. After several minutes, officers were able to get Mr. Peterson to cooperate for the final booking process and were able to fingerprint him and live scan him. After fingerprinting, Mr. Peterson further refused to cooperate, getting into his jail cell while pending his arraignment. Mr. Peterson started to resist in the jail cell, refusing to cooperate with the booking process by refusing to take off his shoes and dress down to one layer of clothes. Mr. Peterson took into a fighting stance by raising his fist towards officers, and Sergeant Baker deployed his taser and advised Mr. Peterson to cooperate. It was then decided that Mr. Peterson would have to be placed on his belly and dressed down to one layer for his cooperation. Officer Villarreal grabbed Mr. Peterson's left arm, and Officer Prokes grabbed his right. Officers assisted Mr. Peterson to the ground where he was dressed down to one layer. Officers then vacated his cell pending his arraignment.
Upon examination of opinion, witness that find the offense charge were committed, there's probable cause the defendant committed the offenses. Okay, and so, Mr. Carmen, your appearance, please, for the record.
Michael A. Carmen, P73824, on behalf of the defendant, Your Honor.
All right, counsel, can you please turn your camera on? All right, thank you. All right, and Mr. Peterson.
Yes, how you doing?
I'm fine, thank you. How are you, sir?
Oh, good. Happy New Year's to you.
Happy New Year to you. And your name, please.
Bradley Thomas Peterson.
Okay, and so, counsel, what are we doing with the arraignment?
Your Honor, he's going to stand mute, waive the formal reading of the complaint.
The court's going to waive the formal reading. Mr. Peterson, you understand that you do have the right to have an attorney. You cannot afford one, the court will appoint one to represent you. Do you understand that?
Your Honor, actually, I would like to represent myself as I always have.
I know, Mr. Peterson, hold on, please. I need to give you your rights, okay? Let me give you your rights. I just want to make sure you're understanding all of your rights. And you've had an opportunity to speak to an attorney today. Is that correct?
For 2 minutes, yes.
Okay. Only for 2 minutes?
Only for 2 minutes.
All right, Mr. Carmen, when did you log in with the Woodhaven PD to speak to Mr. Peterson?
When? What time?
Yes.
Took me a while to get a hold of him. I called at 1:43, then I called again at 1:57. Then I called at 2:01, and I spoke to him for 7 minutes.
Okay, so Mr. Peterson, it was more than 7 minutes. There was more than 2 minutes. It was 7 minutes.
It didn't seem like it. I'm still in jail, Your Honor.
Well, okay, all right, but so, Mr. Carmen, I'm not saying I didn't believe you. I just wanted it for the record, because it was my understanding it wasn't only 2 minutes, so I just wanted you to state on the record.
No problem.
Because Mr. Peterson has stated 2 minutes.
And just to be clear, Your Honor, we did not limit his time on the phone.
To be released in custody. These bond conditions apply. You can't leave the state.
Just to be clear, the Woodhaven Police Department did not limit his time for his phone call.
Hold on, Mr. Carmen, are you in another court?
Yeah, I'm in another court doing an arraignment on 33rd District Court right now.
Okay.
They gave me both of these at once, but I was told I had to call yours right away.
Yes, because I have a pressing matter in 5 minutes. So I just need for the other matter to not interrupt the record. But, so Mr. Peterson, you understand that you also have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury, and you also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights?
Yes, I understand, Your Honor.
All right, the court's going to enter a plea of not guilty on your behalf. Schedule this matter for probable cause conference, January 21st. We'll just do it at 8:30 a.m.
Can I speak, Your Honor, after you're done?
Just one moment. And then as to bond counsel.
Your Honor, just so the court's aware, my client reports being unemployed. He is a caregiver for his best friend's daughter who has some mental issues. She's age 43. Informed me that he has always come to court, never missed court during all the court cases he's had. Would ask for consideration of a personal bond, please.
And also, one more thing, Your Honor.
Yeah.
I mean, that's absolutely correct. You do remember me. I've never missed any court dates. But also, I would like to have because this is a preliminary examination on the 21st, I believe you said.
It's a probable cause conference, sir.
Probable cause. Okay. So, is there any way that the state of Michigan and the city of Woodhaven can give me the notice that I guess that they issue to me or something of no trespassing in that school or in every school in the state of Michigan or whatever it was? It's a notice, I guess, that they're supposed to give somebody for trespassing. And I never received any notice. Is there any way the state of Michigan and the city of Woodhaven can find that notice?
Well, sir, that will be one of the documents for discovery, I presume.
Oh, okay. I didn't know.
Okay.
I didn't know.
Detective Sergeant Vespermi, would you like to address bond?
Yeah, I'm gonna ask for a cash bond and also some type of injunctive order prohibiting Mr. Peterson from being on or near Woodhaven, Brownstown school districts.
In Your Honor, I'm asking for a personal recognizance. I don't have nothing. You know I always show up for court. I always have showed up for court. And I've always tried to be respectful. I mean, you know, I'm eccentric or whatever, but I've always tried to be respectful.
All right, so just one moment. Sir, do you have any family members or children that attend the Woodhaven Brownstown School District?
No, I don't. I don't have no problem not going back there no more. Not at all. That's not a problem. That's not an issue. I'm a public protester, as you know, and I was publicly protesting at that time that they arrested me.
Hold on, sir. Sir, hold on. You can't talk about the case. But I mean, anything you can if you so choose, but anything that you say about the case can be used against you in court, sir. All right.
Mr. Peterson, I advised you of that. You remember that?
Well, it was true.
Not to talk about any of the facts of the case, okay?
Yeah. But I'd like a personal recognizance bond, Your Honor. I've always.
He already knows that. Stop talking.
All right, so here's what the court's going to order. Based upon the allegations, based upon Mr. Peterson's continued violations of the law within the cities of the 33rd District Court jurisdiction, given the allegations in this matter that resulted in injury to an officer, the court is going to order the following conditions. You're not to have any contact with any Woodhaven Brownstown School employees. That's phone contact, text message, email, social media, third party, anything of the like. You're not to enter the property at any Woodhaven Brownstown School's property. So, sir, even if it isn't a school, but it may be a building owned by Woodhaven Brownstown School District, you are not to enter that property. You are not to possess or have access to any firearms and or any weapons. Do you have any of those, sir?
No.
All right, and you already have a GPS tether through the Wayne County Jail. And then the court's going to also state that one of the conditions, or the purposes of bond and the factors that the court has to consider is whether or not an individual will appear in court. The court also is required and must take into account the nature of the allegations as well as the criminal history of the defendant. In this matter, as well as the safety of the public. And in this matter, based upon the allegations in this allegation, the allegations in this instant matter, where it's alleged that Mr. Peterson's actions resulted in the injury of a police officer, as well as the continued issues that Mr. Peterson has in the 33rd District Court jurisdiction, the court's going to order a $10,000 10% surety bond.
Your Honor, I've always showed up for my court cases, and I was assaulted too in this county jail by
Sir,
police.
let me be very clear.
I was assaulted by the police in this county jail, Your Honor.
I cannot indicate that you have failed to appear. I indicated.
I've always appeared.
Excuse me.
I've always appeared. I've always appeared in court.
Sir, you stop talking so you can listen to what I'm saying. I indicated the other factors that the court must consider in assessing bond. Appearance or likelihood of appearance or likelihood of non-appearance is not the only factor that a court must consider for bond purposes. So
Okay.
I was clear with what other factors I considered, and that is how I came up with this bond.
Well, I don't have no money to get out of jail, and I've done nothing wrong. I mean, I literally have done nothing wrong.
Okay, we'll see you back on January 21st.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor. Have a great day.
Hey, can I talk to my attorney? When am I going to talk to my attorney again?
We can put you back in a breakout room if you'd like. But just so you know, you're going to be getting a new attorney for felony matters because of the nature of the charges.
A new attorney for felony matters?
Yes, I explained, Mr. Peterson. I'm just the arraignment attorney.
See, you didn't even explain that to me.
Okay, we're going off the record.
And so how much do I got to come up with to get a bond?
Okay, we're gonna go off the record, and I have to log off here because I have something pressing that I need to be at 5 minutes ago.
I'll explain it to you, Mr. Peterson.
Okay, yeah. What is it?
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. Today is an interpreter.
I need an interpreter when I cannot express myself somewhere.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed, we're going to start bringing people in person. You're going to learn how to act in a corporate.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it? Okay.
Come and go, so
I'm sitting up here, I'm the one that needs a drink.